Y.H. Liman Esquire filed a written address dated 3rd October and filed 4th October and argued same. Meanwhile, the second defendant never put in an appearance despite the proof of service of being served with the originating summons and all other processes. Summary of facts. The case of the plaintiff, as stated in the affidavit in support of the originating summons, is that the plaintiff is a member of the first defendant in Buniadi ward of Gujba local government of Yobe State, who purchased the expression of interest form and nomination form of the first defendant and emerged as its candidate for the office of member, House of Representatives for Gujiba, Gulani, Termoa, and Damaturu Federal Constituency of Yobe State, that he was screened by the screening committee of the first defendant and issued with a screening certificate indicating his qualification to contest for membership, and that having participated in the primary election and being the only aspirant that purchased and returned the expression of interest and nomination forms for Gujiba, Gulani, Termoa, and Damaturu Federal Constituency, he was affirmed and declared nominated as candidate of the first defendant to contest the primary election of the first defendant for Yobe North Senatorial, Yobe North Senatorial primary election conducted on the 26th May 2022. The plaintiff was then issued with certificate of return by the first defendant, which evidenced that he was the candidate whose name will be submitted to the second defendant, and was subsequently issued with the second defendant's nomination form, INEC nomination form, which he filled and submitted to the second defendant. The said INEC nomination form confirming valid nomination was published and displayed by the second defendant to the general public as part of the requirement for the 2023 elections, and that on the 25th day of July 2022, upon inquiry at the headquarters of the second defendant, he was reliably informed that his name was substituted by the name of the first defendant, with the name of one Mohammed M. Bukar, now late, on the 15th day of July 2022. That the plaintiff, upon hearing this development, immediately wrote a protest letter to the first and second defendants protesting the alleged withdrawal of his candidature, and also submitted a similar protest letter to the resident electoral commissioner, Yobe State, in that he never withdrew or relinquished his candidature to the said Mohammed M. Bukar or anyone else, and that having emerged as the candidate of the first defendant is under a duty and obligation to retain his name as its sole candidate for Gujiba, Gulani, Termoa, and Damaturu Federal Constituency in the upcoming 2023 general elections, and that except upon his death, the plaintiff is the only person that can validly withdraw his candidature of the said defendant, of the first defendant for the constituency in question. And the first defendant lacks the powers to either withdraw or substitute his name as his candidate. Having already submitted same to the third defendant, plaintiff stated that he never knew of any hearing or proceedings conducted as part of internal mechanism of the first defendant to address his complaint, to confirm if he authorized his substitution and replacement with the said Mohammed M. Bukar or any other person. Thereby, he remains the candidate of the first defendant and ready to prosecute his mandate accordingly, and seeks the intervention of this honorable court to help him reclaim his mandate in accordance with law. Counsel to the plaintiff, Y.H. Liman Esquire, in his written address formulated 4 issues for determination. The first issue being whether, in view of the provisions of sections 845C and section 847 of the Electoral Acts 2022, and having regard to the provisions of the Constitution of the People's Democratic Party and the guidelines for the nomination of candidates for the 2023 general elections, it is lawful for the first defendant to recognize, nominate, or forward, as the case may be, the name of any person other than the plaintiff as its candidate for Gujiba, Gulani, Termoa, and Damaturu Federal Constituency of the House of Representatives in the 2023 general elections. Learned Counsel submitted that where a political party conducts a primary election and a winner emerges, such a political party is duty bound by section, Such a political party is duty bound by section 84(5)(c) of the Electoral Act to submit the name of the winner as its candidate to the second defendant. Where the political party decides to do otherwise, the winner of the primary election can approach this court for its intervention and relied on the cases of Lere versus APC 2020, Olugbemi versus Lawrence 2017, Saki versus APC 2020, etc. Counsel argued that the relationship between the plaintiff and the first defendant is intended to be regulated by the Electoral Act. The plaintiff having satisfied the requirements of the Electoral Act, the first and second defendants should accord the plaintiff all the entitlements under the provisions of the Act and urge this honorable court to hold the first defendant to account by stopping the first defendant from violating its own constitution and the Electoral Act and reverse its action of substituting the plaintiff's name after winning its primary election. That the first defendant, in accordance with section 84(2) of the Electoral Act 2022 and its guidelines for nomination of candidates for the 2023 general elections, conducted primary election for Gujiba, Gulani, Termoa, and Damaturu Federal Constituency of the House of Representatives, wherein the plaintiff won the said primary election, being the sole contestant. The first defendant purported act of submitting the name of late Mohammed M. Bukar afterwards in place of the plaintiff is unacceptable in law and therefore null and void, and urge the court to so hold and declare the plaintiff as the lawful candidate of the first defendant for the Gujiba, Gulani, Termoa, and Damaturu Federal Constituency of the House of Representatives. The Learned Counsel argued further that the plaintiff personally deposed to the affidavit in support of this suit that he has not withdrawn his candidature for Gujiba, Gulani, Termoa, and Damaturu Federal Constituency of the House of Representatives for the upcoming 2023 general elections. For completeness of argument, the plaintiff is alive, and this should settle any argument on the intentions and purpose of the plaintiff. Counsel urges the court to resolve this issue in favor of the plaintiff and to hold that it is not lawful for the first defendant to change the result of the primary election in which the plaintiff emerged as winner, and also not lawful to substitute the name of the plaintiff with other person as candidates of the first defendant for election in disregard to the provisions of the Electoral Act. Counsel argued issues number 2, 3, and 4 together. Learned Counsel submitted that the totality of the exhibits laid before this honorable court confirms that there was total compliance with the Electoral Act and the emergence of the plaintiff as the first defendant's candidate for Gujiba, Gulani, Termoa, and Damaturu Federal Constituency, and that by the provision of section 84(5)(c) of the Electoral Act, the operative words employed by the above quoted section is to ensure that political parties as a duty and obligation forward to the second defendant only the names of aspirants validly declared winners of a primary election. The word used is shall. It is well settled in law that where the word shall is employed by a statute, it implies a command, mandatory order, and a directive without option. Counsel referred the court to the case of National Assembly versus CCI Company Limited 2008. Therefore, the first defendant is under a mandatory duty to submit the name of the plaintiff to the second defendant as his candidate for Gujiba, Gulani, Termoa, and Damaturu Federal Constituency. That the first defendant is not imbued with any virus to act contrary to the outcome of the primary election. and referred the court to the case of Olugbemi versus Lawrence 2017 LPELR, where the respondent plaintiff was the declared winner of his party primary election, but the party forwarded the name of the appellant. The court unanimously dismissing the appeal held that a political party does not have the power to act contrary to the outcome of its primary election except in very limited exceptional circumstances, and that those exceptional circumstances are as provided by Section 31 and 33 of the Electoral Act 2022, and that the plaintiff has stated in his affidavit that he did not at any time write any notice to the first defendant to withdraw his candidature. Therefore, it is clear from the above section that the first defendant acted ultra vires in clear contravention of the law and asked the court to declare the act of the plaintiff replacement as null and void and grant the plaintiff's relief as procedure was not followed in this case. Learned counsel, in conclusion, contended that based on the submissions in this written address, and which anchored on the materials placed before this court and which are also rooted in the constitution of the first defendant and its guidelines of nomination of candidates, urge this honorable court to answer all the questions raised in the originating summons in favor of the plaintiff and against each of the defendants jointly and severally as per the relief sought in the originating summons. In response to the first defendant raised a preliminary objection to the jurisdiction of this honorable court, contending that the suit is incurably defective and fatally incompetent, having regard to the mandatory provision of Section 97 of the Sheriff and Civil Process Act, that this honorable court ought to set aside the issuance of the originating summons in this suit for failure to comply with the mandatory provision of the stated law. Thereby, this honorable court lacks the jurisdiction to entertain, hear, and determine an incompetent suit. Counsel to the first defendant, J.J. Usman, SAN, in his written address in support of the notice of preliminary objection formulated these: whether the honorable court ought to set aside the issuance of the originating summons in suit number FSC DMCS 15-2022 between Abdullah Idris and People's Democratic Party and one another for failure to comply with the mandatory provision of Section 97 of the Sheriff and Civil Process Act, Cap S6, Laws of the Federation of Nigeria, 2004. Learned counsel answered the above issue for determination in the positive, in that the subject matter is not within the purview of what this honorable court can adjudicate upon, and due process was not followed in the initiation of this action. Thereby, this honorable court is divested of its jurisdiction to entertain, hear, and determine this matter. Respondent, having failed to comply with the mandatory provision of Section 97 of the Sheriff and Civil Process Act, etc., and that the court must take judicial notice of the fact that the first and second defendants are in Abuja FCT, outside Damaturu, the place of issuance of the originating summons. Counsel submitted that it is pertinent to say that on the face of the originating summons, which is the originating process, in this case, the address for service on the first and second defendants is Abuja FCT. However, there's no endorsement that the originating process issued in Damaturu is to be served at Abuja outside the state place of issue, and that it must be emphasized that compliance with the above provisions of the Act is mandatory, as the word used therein is shall. It is settled law that the word shall, where used in a statute or rules of court, is mandatory and requires strict compliance. It is not discretionary or permissive. Thereby, where an originating process fails to comply with this provision, the said originating process is incurably incompetent and robs this honorable court of its jurisdiction to entertain the matter. Nana Silk submitted that the Supreme Court adopted this principle in honors of MV Arabella versus Nigeria Agricultural Insurance Corporation, 2008. Learned counsel contended that recently the Supreme Court had, in a similar case to the present one, had reason again to restate the importance of compliance with Section 97 of the Sheriff and Civil Process Act, and also the effect of the non-compliance in the case of People's Democratic Party versus Independent National Electoral Commission 2018, LPELR, Supreme Court. And the above position of the Supreme Court has not changed. Recently, it was affirmed in Omar Jali versus David 2019. In the instant case, the originating summons issued by the Honorable Court in Damaturu, Yobe State, and served on the first and second defendants in Abuja without complying with Section 97 of the Sheriff and Civil Process Act renders the originating summons void and robs the Honorable Court of its jurisdiction. It is a nullity, same ought to be set aside and the matter dismissed or struck out, and urge the court to so hold. In his written address in support of counter affidavit in opposition to the originating summons, the first defendant counsel formulated a sole issue for determination whether the plaintiff has proved his case to be entitled to the relief sought in the originating summons in suit number FSC GMCS 15-2022 between Abdullahi Idris versus People's Democratic Party and one other. Nana Silk argued that in civil proceedings, the burden of proof as provided by Section 133 of the Evidence Act 2011 is on the party who will fail if no evidence is given on the other side. Planet SAN submits that the law is now firmly settled that in a declaratory action, the plaintiff must succeed on the strength of his case and not on the weakness or even on the admission by the defendant, and that the sole onus probandi in this action lies on the plaintiff, and he must succeed squarely on the strength of his case and not on either the weakness or admission of the defendant, and that from the plaintiff's affidavit in support of the originating summons, there is no iota of evidence to show that he has discharged this legal burden placed on him, and therefore have not proved his case, as the defendant has not shown that the plaintiff, upon withdrawing from the election, received the sum of 5 million naira as refund for his expenditure. This was evidenced by the affidavit of Salisu Ibrahim, Exhibit E. Therefore, premise on the above, it is crystal clear that the plaintiff has voluntarily withdrawn from the election, and it is also too late in the day to complain. And the Section 31 of the Electoral Act 2022 permits withdrawal of candidates from election. Counsel to the plaintiff in his written address in opposition to first defendant's notice of preliminary objection submitted that the issue that arises for determination of this honorable court is whether the plaintiff respondent must endorse this originating summons for service outside Yobe State, having regards to the provisions of the Federal High Court Civil Procedure Rules 2019 and the decision of the Supreme Court in the case of Boko versus Nungwa and others 2019. Learned counsel submitted that the first defendant's notice of preliminary objection is misconceived, incompetent, and abuse of court process, as the entire arguments canvassed by the first defendant are contrary to the current position of the law as it relates to the applicability of Section 97 of the Sheriff and Civil Process Act, SUPRA, on matters instituted at the Federal High Court, where all the parties reside within the 36 states of the Federation, and that the law governing service outside jurisdiction as it relates to the Federal High Court is Order 6, Rule 13 of the Federal High Court Civil Procedure Rules 2019, which listed the circumstances under which an originating process may be issued and served outside the jurisdiction of the Federal High Court. Counsel contended that the cumulative effects is that the words outside jurisdiction simply means outside Nigeria. The Federal High Court is one high court with jurisdiction all over Nigeria. Its judicial divisions are created only for the purpose of administrative convenience. and that this position has been given judicial credence by the Supreme Court in the case of Boko versus Lungwa 2019. And at page 445, paras A to B, specifically held that the case of owners of MV Arbela versus Nigerian Agricultural Insurance Corporation, SUPRA, heavily relied upon by first defendant in this case, was decided based on a repealed law, and therefore by implication ceased to be the position of the law. In conclusion, and in line with the arguments and judicial authorities cited, counsel urged the court to resolve the issue for determination in the negative and in favor of the plaintiff respondent, and to accordingly dismiss the first defendant applicant's misconceived preliminary objection with substantial cost. To fully determine all the issues arising in this suit, this court formulates the following issues, two issues. First, whether or not this honorable court ought to set aside the issues of the originating summons in suit number FSC DMCS 15/2022 between Abdullahi Idris and People's Democratic Party, and one other for failure to comply with the mandatory provision of Section 97 of the Sheriff and Civil Process Act. Cap 6, Laws of the Federation of Nigeria 2004, and 2, whether or not the plaintiff has proved his case to be entitled to the relief sought in the state originating summons. On the first issue, whether or not the Honorable Court ought to set aside the issuance of the originating summons in suit number FSC DMCS 15/2022 between Abdullahi Idris versus PDP and one other for failure to comply with the mandatory provision of Section 97 of the Sheriff and Civil Process Act, SUPRA. Jurisdiction is generally a crucial and radical question. A challenge to a court's jurisdiction must necessarily be determined first. If a court lacks jurisdiction to determine a matter, then all proceedings undertaken by the court becomes a nullity, however well conducted. That makes jurisdiction a threshold matter. In University of Ilorin and others versus Oluwadare 2009, the Court of Appeal, Panweze JCA, as it then was, opined that jurisdiction is to a court what a gate or door is to a house. That is why the question of a court's jurisdiction is called a threshold issue. It is at the threshold, that is the court, a prospective litigant must satisfy the gatekeeper that it has a genuine cause to be allowed ingress. Where he fails to convince the gatekeeper, he will be denied access to the inns of the temple. The gatekeeper, as vigilant as he is always, will readily intercept and query all persons who intrude into his domain. To be able to ventilate a grievance, a prospective litigant has to ensure that he addresses his complaint to the competent court. That is so for an incompetent court will have no jurisdiction to attend to his entity. PP 43 to 44, paras A to A. The law is settled on how to determine the jurisdiction of the court. See Gabriel Madripoli and others versus Johnson in Kendilim 1962 to All Nigerian Law Report 587 at 592. A plethora of cases have re-established that jurisdiction has impact on competency of the court and is determined on the following principles. 1, it is properly constituted with respect to the number and qualification of its members. 2, it has jurisdiction of that over the subject matter. 3, the action is initiated by due process of law. And 4, any condition precedent to the exercise of its jurisdiction has been fulfilled. And the combined effect of the second and third conditions mentioned above is that the court's jurisdiction abates where the plaintiff in his claim fails to disclose a cause of action. Now, in determining this matter, this honorable court will resolve the contention of whether the plaintiff respondent must endorse his originating summons for service outside Yobe State having regard to the provisions of the extant laws and judicial authorities. It is important to stress that the issuance and service of processes is very fundamental. It is important, it's very fundamental to the assumption of the jurisdiction by the court of law. If issuance and service of processes is basically defective, then the court obviously lacks the jurisdiction to entertain same. See the case of United Bank for Africa versus Mr. Abbas Issa Mohammed, 2012, All Federation Weekly Law Report. But they Judge Vivo JSC, who delivered the lead judgment in the case of Izeze versus INEC and others, 2018, construed the provision of Section 97 of the Sheriff and Civil Process Acts and came to the conclusion thus, quote, service of an originating process without the endorsement as clearly stated under Section 97 supra is not an irregularity. It is a fundamental defect which renders the originating process void. The Supreme Court placed premium on the honors of MV Arabella versus Nigerian Agricultural Insurance Corporation, Supra. MV Arabella, in reaching its decision, same thing in People's Democratic Party versus Independent National Electoral Commission, 2018. All the above cited cases were cited by the Leonard Silk, counsel to the first defendant in aid of its argument that failure to comply with the mandatory provision of Section 97 of the Sheriff and Civil Process Act robs this court of jurisdiction to adjudicate this matter. This mode of thinking is often brought in furtherance of a Supreme Court decision in honors of MV Arabella Supra, which was delivered sometime in May 2008 by the then Justice Ogbagu JC, retired. By the said decision, processes filed in one of the divisions of Federal High Court and to be served in another was decided as one which is to be served outside the jurisdiction of the court from whose registry the process was issued. When one reads the provision of Section 19 of the Federal High Court Act and the provision of Order 6 Rule 31 of the Federal High Court Civil Procedure Rules 2019, the legislature has provided that for the purposes of its jurisdiction, the Federal High Court shall have jurisdiction in the entire Federation. And by the rules made by the Chief Judge of the Federal High Court, outside jurisdiction in respect of service to processes under Order 6 is defined to mean out of the Federal Republic of Nigeria. The Supreme Court decision in MV Arabella Supra has made it mandatory that applications such as this is required to be filed in respect of processes issued in one division of the Federal High Court and to be served in another division, notwithstanding the clear and specific provision of Section 19 of the Federal High Court Act. The Federal High Court is the only court of first instance in Nigeria whose chief judge or any of its judges can be directed to sit in any of the 36 states of the Federation, where it already has divisions. This explains, in my view, the rationale for the provision of Section 19 of the Federal High Court Act. Again, when one reads the Sheriff and Civil Process Act, the National Assembly, conscious of the provision of Section 19 of the Federal High Court Act, deliberately did not include the Federal High Court as one of the courts whose processes can only be served in any part of the country except with the leave of the issuing court from whose registry the process was filed. As far as I'm concerned, it is an erroneous situation that leave of this court is to be obtained to serve a process issued by the Federal High Court Damaturu Division and to be served in its Abuja division. This is a court that has only one chief judge, who the Constitution of the Federal Republic of Nigeria, 1999, and the Federal High Court Act gives the power to superintend all the 36 divisions in all the states of the Federation. The analysis I've endeavored to do or to make goes to show that it has changed for the better. The current situation is that the Supreme Court has reviewed its decision in MV Arabella as it realizes that That decision seems to work hardship in relation to the Federal High Court, who was not listed in the Sheriffs and Civil Process Acts. The Supreme Court reconsidered the ratio of its decision in MV Arabella and have set it aside. The Supreme Court, in the words of the late jurist, Honorable Justice Kayode Esho, retired, is not infallible because it is a final court, but it is final because it is infallible, as appeals against its decisions, even if it is wrong, only lies to God. But the court has often, as it finds it necessary, reviewed its previous decisions in subsequent cases where such decisions may have been